You're listening to the Generational Wealth Through Commercial Real Estate podcast. Your host, Will Smith, is a former NFL player that found his passion in commercial real estate. Every week, you will learn from industry experts everything you need to know to get started investing in commercial real estate to build generational wealth.
Hey, thank you for tuning in today. You're listening to the Generational Wealth Through Commercial Real Estate show, and I got a very special guest lined up today, Steve Wallace. We're going to be talking about due diligence from a attorney perspective. But before we get into that, if you're watching this for the first time on YouTube, or if you're listening for the first time on iTunes, do me a favor and go ahead and hit the subscribe button. And if you've been watching this show and it's been adding value to your life, I would really appreciate it if you would just take maybe a minute or two to write a quick review on what this show means to you, because these 5-star reviews are how I keep bringing on rockstar guests like the one I have today. But now that we got the housekeeping out the way, let's go ahead and get into today's content. Steve Wallace has been an attorney since 1999. He's licensed and barred in 3 states, right?
Yes, sir. Florida, New York, and Texas.
Yeah. So he's in 3 states, and he's been doing this for over 20 years now. So he got some value to add to us. Steve, man, appreciate you coming on the show today. Just tell us a little bit about, I guess, who you are and how you got into real estate.
Sure, and I truly appreciate the opportunity, Will, for having me on the show. And I know as soon as I get off this podcast, I'm smashing subscribe on YouTube, and then I'm writing you a 10-star review. So
I appreciate it, man.
So I grew up in upstate New York, and I'm actually the first one in my family to graduate college and ultimately go to law school. So I'm the first. I grew up a background of a very blue collar background, yeah. And my father, my grandfather, they were blue collar workers. They were Teamsters, or organized labor. And my grandfather, who I learned a lot from, he was a small business owner. He had an Army Navy store, and he sold. I grew up in Syracuse, New York, so he sold a lot of Syracuse University paraphernalia on campus. So, so I kind of lived out everybody's dream, because I went to college. I was the first one in my family to go to college, and I went to college in Massachusetts, and then I went to law school at our golden child. I went to law school at Syracuse University College of Law, but it's a very cold, kind of dreary type of place. So I knew as soon as I graduated law school that I was going to leave upstate New York. And my first stop was Dallas, Texas, and I worked for a large firm in Dallas, Texas, and I was doing corporate securities work. And also, and the interesting thing was, a lot of the deals that we were doing were real estate syndications. Yeah. And so that's how I kind of got my first taste of it. I was on the corporate side, and then my mother retired in South Florida, and so I always wanted to live near the beach. And so I moved to South Florida in 2002. And I got hired at a small firm being a corporate attorney, but every deal I did was real estate based. Right. So I kind of cut my teeth on handling real estate, a lot of both on the corporate side with the securities, setting up the syndications, structuring the economics of the transaction, but then also the nitty gritty, what we call dirt lawyers. So I did the nitty gritty work in the acquisitions and the dispositions. And so, ever since then, I've been a real estate lawyer. I still do a lot of corporate work. So I'm kind of one of the few attorneys that I can kind of cross both boundaries for, investment companies like yourself. Yep. And so in 2012, if you thought it was crazy taking 3 bar exams, I took a board certification bar exam in real estate. And so Florida bar rules allow me to say I'm an expert in real estate law. So that's why you've had me on here today.
Awesome. Yeah. Now, you do have your own company now, right? What's the name of your company?
Sure, it's the Wallace Law Group, and you can find us, if you don't mind a little self-promotion. Yeah, you can find us online at the Wallace, Wallace, lawgroup.com.
Gotcha. All right, man. So, I have a lot of guests come on the show, and we talk about, commercial real estate, but, more specifically, most of the guests that's been on has been around multifamily. Mm-hmm. So, man, I want to really talk about, the due diligence side of investing in real estate. You know, the part that nobody ever freaking thinks about until it's too late. Let's dig into due diligence. What's the first thing a potential investor should be looking for when they're doing their due diligence?
Sure. Well, it really starts because oftentimes, depending upon when I'm involved in the process, I oftentimes am involved once the contract's signed, if it's a smaller deal. But the best thing to do is just think about what you need to look for. And when you're evaluating the transaction, when you're negotiating the terms in your letter of intent. And oftentimes what I recommend to my clients and referral sources like yourself, I would attach a list of the due diligence items, because oftentimes you don't know what you don't know. So because you're negotiating kind of in the dark initially what a fair price is, because you haven't looked under, turned over the rocks and looked under all of the different things that you need to look for.
Yep.
But we can go into detail, when you're ready, on the certain items that we need, that on almost every transaction, and we can look, we can kind of focus on the multifamily, but oftentimes they kind of go across the asset classes.
Yeah. No, I mean, that's very important what you said. Going into your LOI, kind of thinking, okay, this is what I really need to be looking for. Because if you drop the ball on one item, I mean, that could blow up all your projections on what you were thinking if you didn't accurately project some expenses that you were going to incur. And just from a negotiation perspective, you want to have as much information as possible, because that's whoever got the most information has the most leverage at the end of the day. So
Absolutely.
That's definitely important. So I mean, let's get into it, man. Like, let's go through those items of what we should be looking for when we're going through our due diligence phase.
Sure. So let's start with, we'll kind of break it up into kind of different pockets of due diligence. So the first thing is financial due diligence. So certainly what you want to get is and ideally for the term of the current seller's ownership, but if they have records from when they were acquiring the property, you want to get copies of all the invoices that were paid for, not little ticky-tack invoices, but large capital improvements. And you want to get a copy of all the warranties on any of the building systems, like the roof, all the different HVAC components in each of the different apartment units. You want to see, when the last time the parking lot was paved over. You want to look at, all the different landscaping issues. If there's different amenities, like for a pool, you want to look at the pool maintenance contract. You want to get copies of all of the permits. You want to get a copy of the certificate of occupancy or certificate of use for the property. You want to get all of the different licenses that you require, because depending upon what amenities are on site, like depending upon the municipality you're in, there may be certain licenses that you're going to need to operate certain functions. Like, for example, if you have a fitness center, things like that, there's a variety of different, licenses that you're going to need for municipalities. You also want to see what their projected CapEx is, because especially if it's a large transaction where you're going to get agency financing, the agency is going to they're going to go over and over and over, and 10 times more and 20 times more over what your CapEx budget is, and they're going to require escrows of those funds. And then the next step is, not only do you want to get their rent rolls, you want to get a copy of all of their leases. And then during the inspection period, and you want to have these before the end of the inspection period, and then also have them updated before closing, is you want estoppel letters. And not estoppel letters signed by the landlord. You want estoppel letters signed by the individual tenants. And oftentimes, if it's a large complex, or depending upon the nature of the property, it may be next to impossible to get those. So
now let me just pause you there for a second. What is an estoppel letter? Because somebody listening to this may say, what the heck is an estoppel letter?
Sure. Excellent question, Will. So an estoppel letter is basically a summary of a lease between all of the different tenants. So an estoppel letter will include the date that the lease started, the date that the lease is supposed to end, the amount of deposit that the tenant deposited with the landlord, the amount of the rent initially, and if it's a multiple term tenancy or if it's been renewed multiple times, what the current rental amount is, if any advance paid rent is made. And these items are particularly important because you need to match up what the tenant estoppel says versus what the landlord's rent roll says. Yeah. And then it also will say if they're behind any months, because you're going to see, you may receive a rent roll, and it may be a historic rent roll or maybe a rent roll. And then just to understand for your listeners what a rent roll is, it's just basically a spreadsheet that's provided by the seller, that kind of outlines the financial points that you're going to need to evaluate the transaction for the amount of income that's being produced from the property.
Yeah. Now let me ask you a question around the rent roll. You know, it's typical to see prepays on it. Now, how was that assessed as far as when you sell? When you sell whatever day you close on, part of that rent goes towards the owner and part goes towards the new buyer. How are the prepays calculated in that?
Yeah, that's an excellent question. So that's one of the challenges. And oftentimes what we put in the contract is there'll be a reconciliation. And oftentimes the reconciliation, it may be, especially if it's a large complex, it may be next to impossible to do it in real time. So oftentimes what we do is we'll escrow a certain amount of funds at closing, and after like 30 days, 60 days, 90 days, there'll be a reconciliation, and then if there's any difference in that amount, then the seller that money will come out of escrow. Or if the buyer needs to, provide an additional credit towards the seller. So generally, just to summarize your question, so generally all of the rent, they're calculated. There would be a credit at the date of closing. And so, like, if just easy numbers, let's say we close on the 15th of the month. So then days 1 through 14, the rent will go to the seller, and days 15 through the end of the month, that would go to the buyer. And then all security deposits that are on hand with the seller, there'll be a credit on the closing statement over to the buyer, they'll have to put those funds into an account, which will be outlined for security deposits.
Yeah, gotcha.
And then ultimately prepaid rent. So, for example, if they paid rent past the closing date, those rental amounts will be credited towards the buyer at closing.
Okay, gotcha.
And I can just tell you from experience, that's always a big fight, and it usually takes, it could take up to a week to get a closing statement right.
Yeah. Just some
patience
of the
is a virtue. Patience is a virtue in this.
Oh yeah,
and then I know I can tell you're an easygoing guy, so you have to have thick skin when you're dealing in this business.
Oh yeah, absolutely. You're 100% right there. I've been in transactions where the seller said, no, I want all of those deposits. All of that rent is my property. I haven't sold it yet. I want all of it. Then you start collecting next month. So there's a lot of headache that kind of goes back and forth with, dealing with that situation. Now, I wanted to ask you, you kind of went past it pretty fast, and obviously because you do this every day, but there's people listening that's, this is new to them. You talked about getting copies of your warranties that come associated with the property. Mm-hmm. What's the importance of getting these warranties, and what should they be looking for when they're looking at the particular warranty?
Well, the first thing you want to look at is to make sure it's transferable to you as the new owner, because not all of them are.
Yeah.
And then you want to understand what exactly. What exact work has been done, and then what exact work is going to be warranted in the future, and also if there's any type of down payments that you need to pay. For example, if there's a copay or anything like that you have to put down a certain amount before it'll be covered. So these are written by lawyers that are locked in a room days on end that just write these things. So even with my legal training, sometimes I get a major migraine headache reading some of these warranties.
Wow. Wow. Yeah, that's. I mean, you need to have somebody looking over something like that, because that can cost you a lot of money if
Absolutely.
you don't read the fine print on it.
And the lender's attorney and the lenders and underwriting, they're going to read all of that too.
Yeah, yeah, absolutely. Now, let me ask you a question around insurance. So let's say that the property is insured, and we're in escrow, and we're supposed to be closing. But while we're in our process to do that, a storm comes and tears the roof up, and
Mm-hmm.
the seller, the check is going to them because they still own the property,
Mm-hmm.
so to speak. But what if they take the money in and they don't fix it, or they don't repair it? Like, how does that, I guess, handled?
Sure. So that's a great question. So generally speaking, and again, it's important to get the attorney involved during the contract negotiation and preparation, because we generally have clause in there. So that would be we call that, as a term of art, it's called the casualty provision. So
Yeah.
generally, the risk of loss before closing is on the seller. So the seller would be able to collect the proceeds, but they would have to repair whatever damage is done or give a credit at closing to the buyer for the cost of repairs. Now, the other thing to keep in mind also is, in another provision of the contract, it's called the conditions precedent to closing. And generally, one of the conditions precedent to closing is that there's been no material change in the property. So another way, if, for example, there's a fight and the seller says, there's no way I'm giving you any of this money,
Yeah.
and there's no way I'm repairing anything, well, then the buyer has a remedy that they could terminate the contract and get their deposits back, because there's a material change in the contract. Generally, what happens is, if you have a motivated buyer and a motivated seller, it's just going to lead to an amendment of the contract and further negotiation. And that's where your expertise comes in.
Right. Gotcha. Now, that was I wanted to know that, because that's something that obviously could happen, and you don't want to be caught with your pants down, so to speak.
Absolutely. I mean, I'm in South Florida, so every year that comes into play with hurricanes, and
Yeah.
You're in North Carolina, and
That's right.
I don't. And so, are you near the coast, or are you in the city?
I'm near the coast. I mean, about an hour from the coast. So any
so
hurricanes
that's
come
an
through,
issue.
we get hit. Yeah.
Yeah, for sure. And then the other thing, and I just wanted to add this because it's tangentially related, is force majeure, and that's a very common thing that's being thrown around in our current state of right now we're in pandemic, and we're in my county, we're under we're still being hit pretty hard with the pandemic, and so the force majeure, it's Latin for an act of God or some other type of issue. So we've seen a lot of deals. I hope this hasn't happened to you, but a lot of deals that I were working on have been stalled or canceled because of this state of emergency. And so, and the issue was, this is technically, you could argue it's an act of God. Certainly it's a virus. But then the other thing is, when a government mandates that there's a shutdown, and all 50 states have been doing that, that would trigger that clause also. And the one thing to look out for all your clients with their business interruption insurance and things like that, there's going to be multiple lawsuits over that, because a lot of carriers are denying business interruption insurance because they say that COVID-19 is not a force majeure.
Wow. Yeah, that can be a messy situation there, man. If they don't want to pay up, and you need the funds to cover your debt service and things like that, man, that could be disastrous.
It is, yeah. I mean, we're seeing a lot of it. I attended a seminar last month just on strategies related to, how to fight those insurance companies when they deny those claims, and across the board, unequivocally, they're denying all the claims.
Wow. Yeah, that's a mess. Well, let's keep going, man. This is getting good.
Sure.
What else should we be looking at? You mentioned that first segment of it. What else should they be looking at?
Yeah, sure. So the next step, which I'll kind of call legal due diligence, and under that auspice, I would include title and survey. So one of the things on every transaction, if it's a cash deal, it's not required, but you're crazy not to do it, is getting title insurance. And so in essence, title insurance is basically protecting the new buyer against anything that pops up, that affects the marketability of title. And the marketability of title means, do you have good, clean title to the property?
Yeah.
No liens or anything like that. So generally what happens is the title insurance company will do a title search, and they'll prepare a title insurance commitment, which is certain requirements that you have to meet before closing, so that the title insurance company will bind a title insurance policy. And it includes things like paying off any liens on the property. But where it comes into play even more would be that, if there's it goes hand in hand with the survey. Your surveyor is going to plot these title insurance exceptions on the survey, and you have to review it. Like, I'm going to give an extreme example. If there's a utility easement that runs through the parking lot, and that's happened on deals that we've had before, or if there's a conservation easement in the middle of something, which in the middle of a amenity. So these are all things that generally in the contract, it provides a certain time frame to review the survey and to review the title insurance policy and to make any type of objections and by doing an objection, you say, seller, I am not going to close until these are satisfied. Right. And so I'll give you some tidbits that I've seen, really within the last 3 or 4 months. We've had a situation where we have a client that's looking to buy a multifamily property, and this is extremely common in the Southeast, is that you look at 2 separate estates. You look at the property estate, and then you look at the oil and gas estate. So if there's a mineral rights underneath the property, certain lenders, if there's not a document recorded in the public record that say that even though the owner retains, or some other party retains the mineral rights, that somebody can't go in and drill on the property. And it's getting even more tricky now in a lot of states where they're drilling for natural gas using fracking and some other technology. And so a lender will not lend on a property if there's a right to enter the land and drill on the property. Makes sense, but I'm saying you would be surprised how this comes up very often, especially like in Texas, and if you're on the Gulf Coast, it's very common.
Yeah, no, that's definitely interesting. Like you said, places like Texas, I would imagine that kind of happens a lot just because of all the oil that's down there. But that's definitely something to take into consideration. And you said that the lender is going to have something in the contract that says that they can't do it as long as they have a debt on the property. Is that how it's written?
Well, no. What it would be is you would record something in the public record. It could be that, or it could also be that whoever has the mineral rights, they don't have even though they retain the mineral rights, nobody can come on the property and drill. And sometimes it's in perpetuity, or at the very least, an accommodation would be as long as the lender has a loan on the property.
Yeah. Gotcha. No, that's definitely good to know. It was good advice. Just because, man, like I said, it's all due diligence is all about finding out everything negative or good about the property. If you don't find it out, then you just shooting yourself in the foot, man. So that's definitely good points, man. What else should we be looking at?
Well, the other thing that I wanted to mention to you, and this is required, and I always keep going back to what a lender requires, because a lender is going to be the most conservative underwriting of any type of property. So the other thing you're going to be required to order is a third-party zoning report. And it's not just a letter from the municipality saying, oh, this is zoned for multifamily, because they wouldn't have been built if it wasn't zoned for multifamily. But some of the other things that you may be surprised to see is there may or may not be enough legal parking spaces. There may be not enough, accessible parking spaces. You may not be allowed to have, in some luxury buildings, they'll have a cafe on site. They'll have, a gym on site. They'll have other social rooms on site. And it may be that you may be able not to have those under the current zoning. And so those are the keys, and every lender, and their third party reports, and we call it a PZR report, because that's the first company that came up with it, and they're still around, and I think they're in Oklahoma. Yeah. And so they have a pretty good thing going, because just the name alone, they get it just based on being the innovator.
Oh yeah, absolutely. Now there was something that I don't know if we mentioned yet. The phase 1 report was the EPA, where they could you talk about that for the listeners?
Sure. Yep, that was going to be. I was actually, great minds think alike, because that was the next item on my legal due diligence. Yep. So every lender, and even if you don't have a lender, it's imperative that you do this, and it's not really that expensive in the grand scheme of things. Yep. Is a phase 1 environmental report. So a phase 1 environmental report, you hire an environmental consultant. And what they do is they look through the public records to see if anywhere within, it's a 5 to 10 mile radius of the property, there's been any type of hazardous waste reported, or any type of spills or anything like that. Yeah. And so if you're within a certain radius of a spill, then you're required, the recommendations, because they give basically an environmental opinion, like I would give a legal opinion on a transaction, and they would say, well, so-and-so is within a certain radius of environmental hazardous substances, but we don't recommend getting any further reporting. Now, if you're close to that, or it's happened on your site itself, because sometimes, certain areas, there's economic incentives to build on brownfield sites and other sites. Yeah. I mean, especially like in the Northeast, where they're like in New Jersey, for example, there was a lot of dumping going on. So there, and even in South Florida, we have certain sites that are designated sites. So especially when you're looking at infill and redevelopment of older properties, it's quite common. Yeah. And so if you're within a certain radius, then the lender or the environmental consultant is going to recommend that you get a phase 2, which is more of an invasive report, where they actually are going to take samples of the property and they do soil tests and things like that. Yep. And then depending upon what comes back, there may be a recommendation that you get more of an invasive test. Mm-hmm. Which is like they actually dig up the property. And so with that in the contract, you have to have the ability to access the property to do these types of tests. Yeah. But luckily I've never had a phase 3 happen, because but I've actually had a couple sites where we knew of there was actually a state environmental order that we had to follow, and the EPA was involved, and we just did the cleanup, and then we closed once we got a no action letter from the municipality. But these are things that anytime you're buying, especially just think about it, you're buying a property where people are going to live, so you absolutely, from a liability standpoint, have to conduct these tests. Yeah.
Now, in that case where you said you guys had to go in and fix the issue, did the buyer get a credit for that at closing? Because they had to put all the money into
They did. Like we did it where we had the seller. We actually, because we wanted to make sure that it was done right. Yeah. We did the cleanup, and then we got a credit at closing for what the cost was.
Yeah. Gotcha. No, that's definitely good to know. I haven't heard of anybody having to do a phase 3 on any of the stuff I've been, looking at. Or
you don't want it. Trust me.
Yeah.
It's actually common when they're redeveloped. Like this is kind of and I actually had posted an article on my LinkedIn account where there's a big thing where there's a lot of repurposing of old retail, especially like old enclosed malls. And so that's a very hot area for construction of multifamily. And so like common things, like for example, if it's an older restaurant and they don't properly dispose of the grease, that's an environmental issue. But the most common is old dry cleaners. Yeah. And you always see cleanup issues over there.
Gotcha. And that's why when I'm looking at deals or underwriting deals that I want to potentially invest in, one of the first things I do is I pull the address of the property up and I look Google Maps. Google Maps is a blessing. You can actually go street view and look if there's any gas stations across the street, laundry facilities around it, laundry
Yep.
mats, anything like that, that's going to raise a red flag for me immediately just because of that.
Yep, absolutely.
So yeah, that's good points. And you brought up a great point there, man, with the redevelopment. There's when somebody's looking at something like a say for example, man, there's a lot of hotels out there right now that's hurting. They haven't been able to rent out their rooms because of COVID, and there's going to be a lot of foreclosures coming. And these hotels are typically in some of the best spots in town. And I've been talking with people that's looking at maybe redeveloping these into multifamily, but that automatically is going to trigger, a red flag for me, just for the fact that most hotels got laundry in house. So, would you kind of look at that the same way?
Well, if it depends what the degree of laundry is, because if it's laundry, just like in commercial grade washers and dryers, I'm not as concerned about it. And if they're pressing the sheets and things like that, it's more like taking it to the level of dry cleaning, because that's where there's more chemicals involved. Yeah. So I mean, you just kind of have to understand what their model is. Yeah. But I don't necessarily think I would be put off right off the bat, but it's certainly something on your list when you're underwriting the deal to ask more questions about. Yeah. Because they don't want to tell you unless you ask. That's the key about due diligence is, and that's the one thing why it's so important to make sure you have a detailed property document list, because they will not give you. You have to assume that a seller is going to hold you to the letter of the contract. That's what I always tell my clients. Like a lot of my clients, I have a great relationship with the seller. Don't worry, they'll give me whatever I ask. And I say, we have to assume that every I is dotted and every T is crossed, and that's all you're going to get. So that's why you have to be more comprehensive in your ask than just have a very kind of small list of items. Because especially if there's a problem, unless you ask, they're not going to tell you. Yeah. Because every contract has that big bold as is, where is, assuming all the faults. Yeah.
Yeah. I know on the residential side, if something's a material fact, then the seller has to tell you, and the broker, if he knows it, they have to disclose it. Yep. But it's not the same in multifamily or commercial real estate.
It does not apply.
Yeah, that's crazy.
Because you should know better. If you're in commercial real estate, you're quote unquote a sophisticated investor, and you should know better, and you should know to ask.
Right. So it goes back to having a rock star attorney on your team, man. You don't want to get caught in a bad situation because you didn't do proper due diligence, man.
There's a lot of lawyers, and I one of the things that I can differentiate myself from other colleagues in the competition is that a lot of lawyers, sometimes they want to paper and dot I's to death and lose focus of what the bigger picture is and what the business points are. And I can stress to you that I'm extremely detail oriented, but the first thing when you come to me and you say, hey, Steve, I got a deal, help me on it, I'm going to say, well, what do you hope to accomplish? Because we can't lose focus on that, because a lot of times, and I love the name of your podcast is generational wealth. And a lot of times when you have clients that are purchasing these properties or selling these properties, this is a game changer. This is setting their family up for generations upon generations.
Right. Absolutely.
And so I don't want to, I am not here to kill the deal from you. My goal is to protect you from yourself and make sure you're protected, but I don't want you to lose. I certainly don't lose sight, and I know you don't want to lose sight of what the end goal is.
Right. No, I mean that's a very, very great point, man. Because like you said, I created the show because ultimately that's what everybody should be striving for is generational wealth. And what you find from wealthy people is they have a team around them. They're not trying to do everything themselves. And, it's having people like you on their team that, will enable them to work towards that goal of, ultimately being, generational wealth free,
Well, I hope to earn the trust in being a part of your team and some of your friends and colleagues and clients team. That's I look at myself more because sometimes attorneys kind of have a negative connotation, and I look at myself as a counselor and a confidant and an advisor. That's really what I'm here to do. And then obviously protect you against the downside. And then you as a business person are going to evaluate, is this risk worth the reward?
Yeah, 100%. Now, what if during our due diligence phase, we ask a question and the seller knows the answer to it, but he lies about it, and we close on it, and then now we have an issue after we close? What kind of remedies do we have as buyers?
Excellent question. So another section of the contract is called representation and warranties. So we try to, if I'm a buyer, I try to make the representations and warranties in the seller's representation and warranties as comprehensive and detail oriented as possible. So oftentimes when you have a contract, most of the attorneys are going to butt heads on that section. When I was a first year associate, they said, okay, well, here's the representations and warranties. We're going to lock you in a room with all these boxes, and you have to go through all these documents to make sure that these representation and warranties are true when you're representing the seller. So we try to be as comprehensive as possible, and a seller's attorney is going to push back as much against us as possible. So one way that we can protect ourselves against that is we generally put a time frame on the time that it will take for these representation and warranties to be good. So ideally, if I'm a buyer's attorney, I want to have it at least 1 year.
Yeah.
If I'm a seller's attorney, I don't want to have it after the day after closing. Generally, kind of a middle ground is between 6 months to a year.
Yeah.
And then if we really think there's a concern, or if we think here's some examples where you would want to create escrow. And so if there's a high vacancy rate, or if we see through our due diligence that there's a lot of evictions going on, or there's some CapEx that's being done, or there's some property, or there's some units that are being remodeled, what we want to do is we want to establish an escrow, and basically, in addition to an escrow, if we're kind of reconciling what the credits are, we also want to have potentially, if we discover doing diligence, there's CapEx, we want to have a CapEx escrow, and then if there's any other issues, like a common thing is the roof or the HVAC. Right. We see a warranty, we get it inspected, there's nothing wrong with it, and then, of course, just the way things work, a month later, there's a problem.
Right.
So, the way is during our due diligence period, and generally you don't really want less than a 60-day due diligence period, and if you can get a 90 to 120-day period, that's the best. At the minimum, I would say 30. Right. But that's really not enough time, because you have to, when you're negotiating that period, you have third-party reports. You got to get your PZR report. You got to get your survey done. You got to get the title work back from the title company. You also have to get the environmental report. Generally, it's a tight time frame, but generally those come back within 30 days. But you want to have a little bit more time. Right. And so you'll discover all of that during the inspection period. And then, usually you negotiate, and it's universally common that you get, in essence, a free look of the property during the inspection period. And so right before you're ready to terminate the contract at the end of the inspection period, there's always a give and take. And you've done many times where you're negotiating an amendment to the contract, providing for all of these things.
Right.
But the one thing that I can stress to all of your listeners out there is that you really have to take the inspection period seriously, and you have to be very disciplined, and you have to be on all of your contractors and third-party consultants to make sure that you get all of this done within the time frame. And if it looks like it's not going to happen, then you just go back to the seller and try to negotiate an extension. And generally, sellers, if they're really motivated to sell, unless they have a bunch of backup offers on the horizon, they'll generally give you another 30 days. But really utilize that time frame
Yeah.
And sometimes if there's multiple offers, you want to have as low of a inspection period as possible because the seller wants to know if they have a real deal or not a deal.
Right. So that's where it gets tight, man. Especially like in North Carolina where I'm at, man, Raleigh, Charlotte, it's very common to have multiple offers on multiple.
Oh, it's hot there in both those areas.
Yeah. So, a lot of times you got to go hard day one. And, for the listeners, going hard means that money is non-refundable, So, what kind of tips could you give the listeners around how to kind of, I guess, work around that hard money? Is there, a way to get some, initial due diligence done before your money goes hard? Like, what kind of tips or advice could you give?
Yeah. So a couple of things that I would recommend is when you're negotiating your LOI, and oftentimes if a seller's got multiple offers, they'll say, that's fine, we'll sign your LOI, it's non-binding, but get all your due diligence done ahead of time, and then we'll go, then when you're ready, sign a hard contract. Right. So that's one thing is, give yourself enough time between the time of the LOI or even while you're negotiating. If you can get a lot of those property documents that you need to review, generally, a lot of these sellers, all they'll do is they'll give you a Dropbox link. Technology is great. When I first started, 20 years ago, we'd have to go through all these boxes and everything. And, I love the online data rooms, and so they should have a link to it or give you a CD. If they're old school, they'll give you like a CD-ROM or a zip drive. Right. And you can go through all of it that way. And a lot of the due diligence can be done. The only thing, though, if your money is going hard, you always want to have a provision in the contract. If there's any title issues or any survey issues or any environmental issues, you still would have the right to get your deposit back.
Gotcha. No, that's good.
So we're hard, but there's some carve-outs.
Right.
Or at the very least, have the hard money deposit be as low as possible, understanding that your buyer knows that if the deal doesn't go forward, you're going to lose it, but it's not a large amount. It's just the cost of doing business.
Yeah. So, obviously you look at a lot of deals, man. What are you seeing? Is it typically 1% of the purchase price?
The hard money or the deposits?
The hard money.
Yeah, I would say between a half a percent to 1%. And then generally, when all the deposits are done, they want you to have between 5 to 10% down.
Yeah. Gotcha. Okay, man, that's good stuff there. What haven't we talked about that the potential investors should be looking at or thinking about?
Well, the other thing that I would mention is, and it ties along with the due diligence period, is before you sign your LOI or at the very least before you sign your contract, you want to understand what your capital stack's going to be. You want to understand how you're going to fund this deal. And so ideally, if you're and most clients, what they'll do, especially if it's a larger transaction, they'll do a joint venture with an equity partner, or they'll syndicate. And for your listeners, what I'm explaining is they'll basically bring in multiple investors to fund the difference between what the loan amount's going to be and what the down payment's going to be, with plus closing costs. So you want to basically give yourself enough time during the inspection period to start raising the funds that you need before the end of the inspection period, or at least have hard, strong commitments from folks, because the last thing you want to do is go past the inspection period and you have 5 or 10% down, and then you get caught with your pants down, no pun intended, when you don't have enough money to close.
Right.
And that happens. You both of us have been involved in those, and that's why you and I are slowly getting gray hairs.
Right. Yeah, no, that's a very, very good point, man. To all the aspiring syndicators, investors out there, you should be talking to your investors now. Any potential investors that you have, you should be talking with them. Going over a pitch book of what a deal will look like, and can I count on you to be involved in this deal? At what level, are you willing to invest? And that's their soft commitment. And just staying in touch with these people. So when you do have an opportunity in front of you, you're not going out there scrambling, trying to find this money, because like you said, once you go past that 30-day due diligence or 60-day due diligence period, your money is hard and there's no getting out, so you got to find a way. So that's a very, really good point, man. I appreciate you sharing that.
And sometimes you're lucky and you can be persuasive and negotiate a couple of extensions of the inspection period or extensions of the closing date. But at the end of the day, that closing date comes, that money better be there or your money's gone. Or at the very least, you're involved in some litigation to try to get your money back.
Right. Absolutely, man. That's a place you don't want to be. Definitely
Absolutely not.
Good deal, man. Well, man, I think we covered a lot. I imagine there's a lot more that you could probably go over. But we're probably at that 40, 45-minute mark now. So, if you could, man, tell my listeners again, how can they get in touch with you?
Sure. So there's multiple ways. You can find us online in our website, and it's thewallacelawgroup.com, TheWallacegroup.com. We also, I'm on LinkedIn, Stephen E. Wallace, pretty easy to find. And I'm on Twitter, WallaceStephen73. We have a YouTube channel, The Wallace Law Group, PL. And soon, and I know I've already asked Will to be a guest, you can find us on all of your favorite podcasts. And my podcast is Attorneys Are Human Too, a podcast.
Awesome. Well, I appreciate you coming on the show today, man. You added a ton of value to my listeners, and we'll definitely be in touch.
Okay, look forward to it. Thank you so much for the opportunity, Will.
Yes, sir.
Thank you for listening to the Generational Wealth Through Commercial Real Estate podcast, brought to you by Onyx Capital Investments. Onyx Capital Investments works with investors nationwide to invest in income-producing real estate in emerging markets. Connect online at www.onyxcapitalinvestments.com to learn more about what we're doing. If we have added value to your life, please leave us a review.